This case starts like so many probation hearings do, quiet, procedural, almost routine. But don't be fooled. What you're about to watch spirals into one of the most frustrating, revealing courtroom exchanges you'll see all year. The defendant here, Richard Kanu, is standing before the court on a motion to revoke his community supervision. Sounds simple, right? Either you followed probation or you didn't. But here's where it gets interesting. This isn't a new probationer. This is his second motion to revoke, meaning the court has already given him another chance before. And the alleged violation? Failure to report to probation. One of the most basic, non-negotiable conditions there is. No paperwork, no loopholes, just show up. Yet as the judge tries repeatedly and patiently to get a straight answer, the defendant begins to contradict himself, backtrack, and deflect responsibility. One moment it's, "I didn't report," the next it's, "I couldn't find the office." Then suddenly it's confusion over what pleading true even means. And that confusion isn't harmless, because every word here carries real consequences. 10 years in prison is on the table. So the question becomes, is this genuine misunderstanding or strategic avoidance? And at what point does patience run out in a courtroom where clarity matters more than excuses? Stay locked in, because this hearing shows exactly how fast deferred freedom can
Court
turn
is
into real
calling
prison time.
2021 CR 11554, State versus Richard Cantu. Can I have parties announced for the record for the state?
Michelle Savella for Mr. Presley.
And are you Mr. Cantu?
Sure.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yeah.
Are you the same Richard Cantu as placed on deferred adjudication in 2021 CR 11554 for the offense of obstruction or retaliation on September 16, 2024 for a period of 3 years? Is that you? All right, state.
Violation of condition number 4 in Bear County, Texas. The defendant, Richard Cantu, did then and there fail to report to the supervision officer as directed for the months of August, September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We wouldn't abandon the remainder.
Any objections to the waivers? Did you understand by pleading true to violation of condition 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No. Are you pleading true to number 4?
True.
Do you understand? No. Listen to me. Are you pleading true to violation of condition number 4? Yes or no?
No. Don't know what I mean.
Oh, so this is what it means. The state is saying that you did not report. Do you understand that?
Yes.
Did you report?
No, I couldn't find a big.
Nope, nope. I just want you to answer my questions. All right. So
This is a critical moment, and if you've never watched a probation revocation hearing before, this exchange explains everything. When the judge keeps repeating the same question, it's not impatience, it's due process. The court is legally required to ensure the defendant fully understands what pleading true means. And in this context, true is essentially an admission. Yes, I violated probation. Once that admission is on the record, the judge no longer has to hold a trial. The court can immediately revoke probation, enter a felony conviction, and impose any sentence within the statutory range, here up to 10 years in prison and a $10,000 fine. That's why the judge keeps stopping him and saying, "Listen to me." This isn't casual conversation. This is the fork in the road between freedom and incarceration. What escalates the tension is the defendant's refusal to answer cleanly. Courts operate on yes or no clarity. "I couldn't find it" isn't a legal plea. And notice how the judge ultimately shuts that down and explains exactly what a contested hearing would look like. Probation officer testimony, proof of reporting, hard evidence. This is the court saying, if you want to fight this, we'll do it the formal way. So ask yourself, if you truly didn't understand probation requirements, would you keep interrupting the judge, or would you be asking for clarification through your attorney?
All right. So you have just pled true to the fact that you didn't report. Do you understand that? Now, whatever agreement you've worked out with the state, I don't have to follow that. Do you understand? I can send you to prison for 10 years. Do you understand? So knowing that I can send you to prison for 10 years and up to a $10,000 fine, do you still want to plead true? Yes or no?
No.
All right, he doesn't want to plead true.
True for the probation office, I could not find the probation office. Yeah.
All right, so here's the thing. This is his second motion to revoke. I know he know what's going on here. So I'm going to explain it to you again. And if you wanted to proceed with saying yes, no, not answer my questions, we can do that. And this will be recalled for a contested hearing. The state will bring in a probation officer or whatever witnesses they need. Do you understand?
Yeah.
Now,
I could not. find
now,
the
listen
probation
to me. Are you pleading true to not reporting, yes or no?
office. No.
All right, so we need a contested hearing. All right. What date for a contested hearing? Failure to report.
I can do the 7th
Do you want to do the 7th
or the 9th.
or the 9th? Now it's up to you. If you want to bring it back for another day, that's fine.
We do second.
All right.
15th.
All right, we'll see you back on the 15th. The state will call whatever witnesses they need to call to seek to prove the failure to report. And what I can tell you on failure to reports, usually the person that needs to be called is the probation officer. And that probation officer is going to come in and say, either you reported or you did not.
I did not report. So I know I didn't report to nobody when I got released the 3 times.
So I don't understand why you're not asking my questions.
But to be saying, yes, I did not see no one, or no, I never went into the door. I'm saying that I never went to see the probation office. Because I never saw him, I never got reported to see him.
Mhm,
I never got his address or his phone number to see.
mhm.
Yes, I wanna move forward with my case. I wanna take it to. I wanna take it all the way, like guilty and not guilty, I play guilty. I pay no contest also, but I never saw my probation officer when I got released. I never had ever seen.
You want to talk to him some more? All right, Mr. Cantu, the last time we were here, you pled true to violation of condition number 4. Is that correct?
Yes.
All right. Did you understand by pleading true to violation of condition number 4, the court could grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yeah,
Knowing that, do you still wish to plead true to violation of condition number 4?
yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it is to grant the state's motion, revoke the defendant's community supervision and sentence him to a term of 4 years in the prison, and then the state would be taken into consideration.
This is
Oh, I
the
see.
turning point. The moment confusion gives way to consequence. When we return to the record, the tone has completely shifted. No more back and forth, no more uncertainty. The defendant now clearly pleads true to the violation, fully acknowledging that he failed to report. And once that happens, the legal gears move fast. The state presents a negotiated agreement, revoke community supervision, and impose 4 years in prison. This is significant. The judge could legally impose more. Remember, 10 years was on the table, but plea agreements are strategic. For the state, it avoids further litigation. For the defendant, it caps exposure and brings finality. Notice how the judge confirms everything on the record: understanding of rights, waiver of appeal, acceptance of the deal. This protects the sentence from being challenged later. And once the court says, "I will follow your agreement," the outcome is sealed. Probation is revoked. A felony conviction is entered. Prison time is no longer theoretical. It's immediate. This is the hard truth of community supervision. It's not a second chance without rules. It's freedom with conditions. And once those conditions are broken, especially repeatedly, the margin for leniency disappears.
Clause number 2025 PF 43375.
All right, is that your agreement?
It is, Your Honor.
Mr. Cantu, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. Odyssey is slow. All right, the court will find violation of condition number 4 true. The court will follow your agreement, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served, take into consideration 2025 PF 43375. There should be no residing in households with minors, no unsupervised contact with minors. Oh, state you may be excused. And the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, sir.
This case is a textbook example of how probation violations unfold in real courtrooms. Not dramatically, not emotionally, but decisively. Richard Kanu was originally granted deferred adjudication, a path that could have avoided a felony conviction altogether. But failure to comply with the most basic requirement, reporting to probation, ultimately led to revocation, conviction, and a 4-year prison sentence. The judge followed the law precisely, ensuring the defendant understood his rights, the consequences of pleading true, and the finality of a plea agreement that waived appeal. This wasn't about harshness, it was about accountability. Deferred supervision only works when defendants meet their obligations. When they don't, the court's options narrow quickly. And that raises an important question for viewers. Should repeated probation violations be treated with more patience, or is prison the inevitable result once chances are exhausted? Drop your thoughts in the comments below. If you found this case as shocking, make sure to hit that like button, share your thoughts in the comment section, and don't forget to subscribe to Audit the Courtroom for more breakdowns of real USA courtroom cases.